Thank you so much. It's such a pleasure to be here today. Thank you for having me. And I'm quite enjoying the energy in the room, especially from that table. It's wonderful. Hopefully we'll get everyone else loosened up with this important topic. So I will be sharing the stage with Caitriona Fay, who's the National Manager of Philanthropy at Perpetual. And she'll be talking in more depth about the philanthropy side of things, and I will be talking about the estate planning basics. Really, we're trying to get a PowerPoint up. Oh, there it is. Excellent. That's perfect. Thank you. So we'll just be taking it back to basics. It won't be too detailed. Essentially, I'd like to touch on a few topics today. What is contained within your estate plan? We think it's simple, but very often there's a misconception about what you can and can't put into your will. The second point is capacity. Mental capacity is very important, and it's the prerequisite behind an estate plan. So I think we need to be quite clear around capacity, and we might all have an opinion about our colleagues' capacity, but there is a rule that is followed, so we'll go into that. And then we'll look a little bit into the contesting of wills. Who can and can't contest wills? What's that all about? But before I get into the slides, I think what is important, and this was touched on a little bit earlier, estate planning, I'd like to challenge your thinking around estate planning. When people hear that I'm an estate planning lawyer, the reaction usually is a little bit of a cringe. That's a very morbid area of law. How can you enjoy it? And what I've found is that there's actually this misconception that estate planning is a conversation about death and dying and everything morbid that everyone tries to avoid at all costs. But what it actually is a conversation about what you deeply love. And so when we are, so in this room, a common bond that is shared here is a love for philanthropy, charitable giving. And so my interaction with my clients who have this strong connection to philanthropic giving is by the end of the estate planning conversation, they've had a very in-depth think about how best to ensure that their wishes take place the way they want to for the ultimate benefit of all parties involved. We don't talk about death at all. We're probably all quite invincible in our minds and immortal, but the real important topic here is, what is it that you truly love? Is it your family? Is it the charitable gifts that you make? What is it? Find out what it is, and then ensure that you have all the documents in place to ensure that it's transferred appropriately. So, with that in mind, I do have some slides. You might. Oh, excellent. Yeah. Thank you so much. And sorry to make you keep turning your heads. You can either choose to look at me or the screen. I won't be offended, that's fine. So firstly, when we talk about an estate plan, it's very common to get confused around what it is that is contained within a will. It's not actually everything that you own, and it's very important to make a distinction between what your estate assets are and what are non-estate assets. So your will essentially only covers assets that are owned in your personal name. So anything owned in joint names automatically transfers to the joint tenant. Anything owned in superannuation is covered independently of your will, and you'll need to put separate nominations in place. Your will does not cover anything in family trusts, any life insurance, anything that is outside of your personal name. So that is the first important step. People think that the will covers absolutely everything. That's not the case. Importantly, there are a few important roles that you need to consider within the will that will have an effect on how the will is administered afterwards. So who will the executor be? What's the role of the executor? The executor really, hopefully, if there's no contesting of the will, the executor's role is quite simple. So they will administer the estate, go through the probate process. It's all very straightforward. But if there's any contesting of the will, that's also the executor's responsibility. So they will need to attend court hearings and represent you after you've passed away. So when you're looking at appointing your executor, particularly if you are intending to make some provisions within your will that might be contentious in any way, it's a good idea to just give some thought as to the burden you might be putting on the executor who will need to represent you after you're no longer around to have to deal with it. And then there are, just within your will, I won't be going through this in too much detail today, but there's essentially a couple of structures that you can put in place to ensure that your estate is essentially protected for the people that you intend to give it to. So you can either choose to set up testamentary trusts within your will, which is a little bit complex, and that's probably a conversation for another time, or you can keep the will really standard and transfer assets directly to the beneficiaries. Now, another important element of an estate plan is your powers of attorney. And these, again, commonly people are under the misconception that powers of attorney operate once you pass away or after death. That's not the case at all. They're designed to operate during your lifetime and are most effective once you lose capacity, if that is ever to happen. And so what you'll find is that there are 3 types of powers of attorney in Victoria that authorise people to act for you in different capacities. So you've got your financial power of attorney. It gives someone the authority to access your bank accounts, make legal decisions on your behalf. It can go as far as allowing them to sell your assets to pay for your ongoing care. So it's a very powerful document, but without it, you put yourself in a very difficult position where you've lost capacity and you need to rely on VCAT to make decisions around who will be appointed on your behalf. There's a medical treatment power of attorney as well, known as morbidly the life support power of attorney. Is the ones that doctors are most interested in. If you were to lose capacity, they need someone to make a decision about your treatment. And personal matters looks at your guardian style decisions. So where will you go for ongoing care? If you need to be put, placed in a retirement home, what does that look like? Where is the location? Who's going to pay for it, etc. So these are actually very, very important documents to put in place that are outside your will, but can have an impact on your entire estate plan. Importantly, your financial power of attorney does not authorise anyone to make a will on your behalf or make any decisions around your estate plan. So it's important that you put those documents together and don't rely on anyone else to do it. And just as an interesting side note, a power of attorney does not allow someone to marry you off as well, so you can rest assured that they won't do anything that you won't agree to. I don't know if that was a sigh of relief or disappointment over there. Disappointment. Then we move on to super. I touched on this before. Superannuation, it's very important to understand that it's not covered by your will, and sometimes there's significant wealth that is captured in your superannuation. So you'll need to prepare some binding nominations to transfer super to your intended beneficiaries. And you need to also bear in mind that these super nominations normally lapse every 3 years, so you can't just set them and forget them. Similar to your will, it's important just to keep this front of mind every 3 to 5 years or so. And then finally, and this will be the point that Caitriona will be dwelling on in more detail, is the philanthropic giving and what you can do within the will. You can get quite creative as to how you leave your bequest or your legacy behind after you pass away. It's not just by fixed bequests. You can choose to make a lifetime legacy, and there are quite incredible stories that Caitriona will go into detail about, where even just a relatively small amount that's left to charities via these legacies and endowment funds can actually have a lasting impact that's quite dramatic. Importantly there, from our perspective, the wording needs to be very specific and accurate, because there can be unintended issues afterwards if the will is deemed to be invalid because of some issues around wording. So here it's a good idea just to get a little bit of advice, but you've got a lot of flexibility in terms of what you can and can't do within your estate plan. Are there any, so that's just the basics. Are there any questions before we move on? Yeah?
Yes, I'd just like to ask a question about superannuation and beneficiaries.
Yeah.
You say that you can nominate these. I was of that I am of the understanding that superannuation
That's correct. That's very true and an important point. So out of superannuation, you have a defined category of beneficiaries that you can choose from, and they include dependents, so spouses or former spouses, children under 18, and if they're financially dependent up to the age of 25, then they're also counted. And then if none of these apply to you, you can nominate your estate to receive your super. So that's your legal personal representative. Superannuation will then fall into your will, and you can be as creative as you like around who receives your super through that means. So you can say, I'll give my super to my friend in my will, bearing in mind that there is just a tax that's applied because they're not your dependents. So those are the avenues that are available to you. Does that answer the question?
It poses another one.
Oh. I will be around to answer questions as well.
I think
yeah.
If you don't mind, we'll go through the normal format, which is we'll do the questions at the end, guys.
But
Because otherwise we could be not letting it at the end.
Yeah, no, don't worry. Look, that's okay. There's only around 4 slides or so there's a lot of talking room for chatter. But I'm glad to see that there are questions, so please don't forget them. So we'll just move on. Mental capacity is very important to understand. And sorry, there is quite a bit of writing on the slide. You don't really need to read it. I will convey the message to you. Essentially, mental capacity from our perspective, from a legal perspective, is different to mental capacity from a medical perspective. There are circumstances where an individual may be looking as though they're losing capacity from a medical perspective, but our test is different, and we can prove that they actually do have capacity to understand what it is that they're signing. So importantly, the definition here is a person with testamentary capacity is commonly described as being of sound mind, memory and understanding. They must be able to understand the nature and effect of what they are doing in executing the will or powers of attorney, and realise the extent and character of the property they are dealing with. And they must also recognise the nature of the moral claims on their estate to which they ought to give effect. So essentially, when we are preparing an estate plan or wills and powers of attorney for any individual, there is a mental capacity test that must be carried out, and usually it's just via a conversation. We can work out whether you have an understanding or not of the document. But it's not whether you remember what you had for breakfast or not. I'm not so concerned about that because I would not pass that test today, and that might be because of what they call baby brain, but anyway, that's not our capacity test. What we're concerned with is, do you understand the nature of the document you are signing? Do you understand the impact of the decisions you are making, particularly when you are choosing to leave beneficiaries out or make some decisions that might be contestable in the future? And do you appreciate, so can you tell me about your assets, about your family accurately? Can we have that conversation without you having to rely on anything for support, without you forgetting what we're talking about halfway? So that's really very important. And I'll give an example, which is actually one of the most interesting client interactions I've had. It was with a gentleman who had lost, he had terminal brain cancer, and the medication that he was taking meant that he lost capacity for 22 out of the 24 hours in a day. And by that, he would not really recognise his family, he wouldn't really know what it was that he was entering into, he had no clue. But in the 2 hours in the morning where he was alert and right before he had his medication, he knew exactly what he intended to do within his estate plan, and he was very switched on. And we were able to have a conversation with his doctors around, well, is this actually accurate? Or is he just claiming to have capacity at that time? And the doctors confirmed that that was actually the case, and we were good to take instructions from him when he had capacity, and then test along the way to ensure that the instructions didn't change. And then when we went to execute the will, at the time when he had capacity, we had a doctor attend the meeting and assess him quite specifically around who he named as his executor, what his assets were, who the beneficiaries were. It was very specific. It wasn't about, there weren't any medical questions. It's not a medical test. And there were a few questions around what's the date today and those types of simple capacity tests. But what we were interested in was whether he appreciated and understood the legal impact of the document he was preparing. And interestingly with this one, he was choosing to leave out his former spouse, who he had not divorced from. He wanted to bypass her and give everything to the children, which you can do. It's not highly recommended, but sometimes it is the case that people want to do that. And so he did that, knowing fully that she would contest the will the moment he passed away. And so for us, the focus was on ensuring that the will was valid in every aspect. We dotted every I, crossed every T. And so sure enough, after he passed away, it probably took less than a week for us to receive a letter from the former spouse saying that there was no way on earth that he had capacity to prepare a will. With his condition, there was no way that it went through. And so we were called upon by the court and the probate office in the Supreme Court to present the evidence, and the evidence was sufficient to prove that the will was prepared validly and that he had the requisite capacity to understand what he was doing at the time. So that's a very extreme circumstance. Those cases come across at my desk like every so often, maybe one every 100 or 200 matters. But it's important to understand what it is that capacity is all about. And I hope this example just highlights that for you. Another important point, and this will be the last point really for us to talk about, is who it is that can contest your will, because this is a hot topic as well. You can do whatever you want within your will, but within reason usually. And if you don't give very clear thought as to who might contest your will, you're really leaving, you could be leaving a mess for your loved ones or the charitable organisations that you hold very close to your heart to deal with after you've passed away. So essentially there's a limited category of people: your spouse, former spouse if they're not divorced, children, stepchildren, very importantly, and a carer in a registered relationship with you. registered carers relationship can contest the will if they feel that they have not been adequately provided for. Now, they've got 6 months from the date of probate to lodge the application, so it is a limited window of time. They can't contest it 10 years later. But importantly, you need to have a think about if you're attending and trying to put a will together and there is someone in this category of people that you are choosing to leave out of the will, you just need to be very, very clear around the reasons why, because their argument in court will be that they had a reasonable financial expectation of a gain because of their dependency on you. So when we have conversations on this topic, we try to put a case together so that after you've passed away, the executor almost is prepared with the paperwork to prove that you actually didn't, this was your true intention for your will. You actually did intend to give everything to charity, or you did intend to give the majority of your estate to a charitable organisation because you have provided for your family in another way. Be very, very specific, because the worst thing that can happen is you leave a mess for people to deal with afterwards. And just because I'm also conscious of time, this is the very last slide. So how to ensure your giving goes to plan. As we said, ensure that it's validly drafted. From a legal perspective, there's very specific wording that needs to be met. Particularly around philanthropic giving, we need to include certain provisions that allow things to be gifted smoothly. But there's also the minor things like all witnesses need to be in the same room using the same pen. There can't be anything clipped to the will. It's very, very, very serious in what the rules are there. If you are considering potentially not dividing your estate equally, or maybe putting in a few surprises in your will for your family that they might not be too satisfied with afterwards, document as much as you can, particularly if you've assisted some of your children a little bit more favourably over others. Try to get something in writing from them to acknowledge that they understand that they've been provided for, if you can. That's sometimes a long shot, but or a loan agreement in place so that it's paid, it's owed back to the estate afterwards. If you have separated from a spouse, a binding financial agreement, often also known as a prenuptial overseas, is a good idea just to ensure that the separation of assets is quite clear. Sometimes it's a good idea, communication is a big thing. If you can communicate your intentions beforehand, either to charities that you might be assisting or to your family members, that's also a very good idea to make sure everyone's on the same page. I'd review your will every 3 to 5 years. Things change. 3 years ago, I had no idea that I would be a parent now, so that's changing everything in my mind, and a trigger to consider a review of my own estate plan. But it's amazing what can come up in that time, and try to seek some advice where necessary. So I hope, sorry, that was a very quick snapshot. But I hope that was helpful, and I will pass on the mic now. Thank you.
Right, so now I have a great deal of pleasure in introducing Ms. Caitriona Fay, who's the National Manager of Philanthropy and Not-for-Profit Services at Perpetual. She's a senior philanthropic leader in Australia with 15 years of private family and institutional grant-making experience in Australia and Europe. Please welcome Caitriona.
It's not as simple as it looks. There's extra I's thrown into my name for fun.
It is
that's my
Caitriona in my
good
defence.
Irish Gaelic heritage. But it does lead to party conversation. But perhaps not the type of party conversation Chantelle has where people avoid you. And in fact, my job's terrific. People often say to me, I get to work with families and individuals who are giving away money for the benefit of communities that they're passionate about. That's what I do day in, day out in finance. So I certainly feel as though I have one of the best jobs in the world, and people gather around me at parties. I'm not sure what that's about, Chantelle, but...
People will be gathering around me after this, I think.
It's not a competition, girl.
It's not. It's not. We'll talk about it in the car on the way home. Perpetual's a really interesting business. Many of you will know it's a 130-year-old trustee company, but I like to remind people that the oldest charitable trust that Perpetual manages is nearly 129 years old, set up by Dame Edith Campbell Walker. It's a really interesting deed, actually. She set it up for a couple of reasons. It's really interesting. She was a living philanthropist in the late 1800s when she established it, which was rare at the time. A lot of charitable trusts were testamentary in nature. But she had realised that as her house service staff, primarily women, were getting older, none of them could afford to go back to Britain. And they had no family in the New South Wales colonies at the time to look after them. So she established a number of cottages on the north shore of Sydney for women who had come to Australian house service and needed somewhere to retire to. And those cottages, amazingly, Urala cottages they're called, still exist today. We did have to approach the Attorney General for a cypre, obviously, to address the fact that there weren't as many women in house service that needed support of that accommodation, but they are now mid-term housing support for women who are exiting family violence situations and managed by Mission Australia. And I really love that story because one of Australia's earliest philanthropists was a woman, and a woman looking after other women and the needs of other women. And I'm sure that she would have been very happy to see ultimately what those cottages were servicing and continue to service today, and will in perpetuity because of the legacy that she's left. So that's the beginning of the Perpetual story. She was a Perpetual client, and from that day until this, we've been working with families around their charitable giving. And a lot of that is living giving, giving either directly to organisations that our clients are passionate about and helping them to arrange those major gifts. And in some instances, it's about establishing structures. And obviously we love talking about structures at Perpetual. Trust structures are our wheelhouse, but charitable trust structures are really interesting vehicles that enable the clients and families that we work with to make gifts of genuine legacy for their communities. So there's a lot of talk about philanthropy at the moment, and there's a reason Chantelle and I are a horse and pony show. It's because we're in a window that you might have heard is the largest potential intergenerational wealth transfer in human history. So over the next 20 years, more money is going to change hands in an intergenerational sense than has ever happened before in human history. And we, I guess at Perpetual, and I think a lot of people that are involved in the charitable space are thinking about this in terms of how do we support individuals who are thinking about that succession of their wealth to really ensure that they achieve what they want to achieve with that transfer. And for many of those individuals and for many of those families, the transfer piece is partly about ensuring that the money that those families have built up over their lifetime actually has meaning in that transfer process. And that's where philanthropy quite often comes into it. It's also going to be very much about what women decide to do. So 70% of that wealth transfer 40% of, let me start that one again. Over 65% of the initial transfer of wealth will fall into the hands of women, so women are going to be really significant deciders. So gentlemen, unfortunately it's probably going to come down to the women in your life to make decisions around the final destination of your transfer of wealth. But ultimately that's a really interesting piece for someone like me, because women are more concerned around bigger pictures in their communities when they're doing their estate plans. So men tend to focus in on family first, women absolutely focus in on family, but ultimately want to consider the broader benefits for community as well. I just want to talk you through a couple of case studies because they're quite interesting. We don't often talk about Australia being a country where there's the type of philanthropic heritage that the United States, say, has. But we've actually got a really unique and interesting philanthropic history that we don't talk about a lot. So I'm going to talk through these 3 little case studies. The first slide's my chocolate from my coffee cup, for anybody who can guess who those 2 gentlemen are. I think I've actually eaten it, Carrie, but don't say that. So the first picture is a gentleman called William Darcy on the left and Walter Hall on the right. Walter Hall, you probably know a lot about the story of Walter Hall. But what you might know is that Walter started his life in Australia here in Melbourne. He didn't do particularly well at prospecting. He was employed by David Jones for a period, didn't particularly like that. Someone offered him a job in Rockhampton, so he went up to Queensland and started working for the National Australia Bank as a branch manager. Now, somebody gave Walter a really, really good tip, because he set up a syndicate to establish what became the Mount Morgan Mine. And the Mount Morgan Mine became, obviously, Australia's very first company to provide over $1 million in dividends. And Walter and his mate William Darcy were the primary beneficiaries of those dividend payments. Now, Walter decided to stay in Melbourne, and we'll get back to his story in a tick. But William was known as a gambler, a philanderer, so he didn't think that there was much for him to do in Rockhampton, so he took his money and he went back to London, and he used to take trainloads of friends to Ascot and have a great time, gambled away a lot of his money. He wasn't particularly good at picking horses, and when he gets down to really the last dollars of his Mount Morgan money, he decides to have one last really big gamble, to take one last really big bet. And that was that there was oil in the Middle East. So he establishes a company called the Anglo-Persian Oil Company with the remainder of those funds. Obviously that bet paid off, and the Anglo-Persian Oil Company subsequently became BP. But that was all from the proceeds of the Mount Morgan mine, so all from Australian dollars that ultimately funded that. And we know that the finding of oil in the Middle East changed that region significantly, and obviously geopolitics more broadly. Walter and his wife Eliza moved down to Melbourne, and they had a very nice life together. They didn't have any children. Walter passed away and left the entirety of his estate to Eliza, and this is actually part of the story not a lot of people know. It was actually Eliza who decided, what am I going to do with these funds? I'm going to establish a space for the benefit of discoveries that might change the humankind ultimately. So she was very ambitious with what she wanted to establish, and obviously set up the Walter and Eliza Hall Institute and a number of other trusts to support scientific research. Walter and Eliza Hall Institute obviously went on to give us Macfarlane Burnet, one of our very first Nobel laureates, and changed the world in terms of what his discoveries in immunology. So Mount Morgan Mine, the funds and proceeds from that ultimately changed the world as we know it today. But the trust structures that Eliza Hall established and ultimately poured into via her philanthropy changed medicine and changed Australia's work in the medical field. And we often hear about Australia punching above its weight in medical research, and it was women like Eliza Hall who contributed to thinking around what the role of philanthropy should be in Australia's early cultural life. I'm going to guess that I probably have to give up my chocky for this next slide. Anybody want to take a punt on who that is? No? Graham Clark. Graham Clark, yep. So Eliza Hall in 1906 met a 16-year-old woman called Vera Ramachiotti, who was quite inspired by Eliza's vision for philanthropy. In 1974, Vera's an older woman. She owns the Sydney Theatre Royale. She decides to sell the Theatre Royale and use the entire proceeds, $6.5 million, to set up a trust structure to support medical research in Australia. So inspired was she by Eliza. The very first gift that she gave was to the Walter and Eliza Hall Institute. One of the earliest gifts that she made, though, was after hearing about a researcher called Graham Clark. Wasn't getting a lot of traction around the Melbourne medical field. They all thought he was a little bit bonkers in terms of what he was going to do. He had a NASA engineer working with him to build the prototype for the cochlear implant, and he'd run out of money. And he approached the Ramachotty Foundations for $15,000 to keep as NASA engineer with him for another 6 months. $15,000 later, 6 months on, the prototype for the cochlea was finalised, and ultimately today we know 500,000 people globally are utilising a cochlea for their benefit. So again, this wasn't a huge grant that was made. It was a small philanthropic gesture that had been inspired in some parts by Eliza Hall through her relationship with Vera Ramachotty. Vera set up her charitable trust structure, and still today, Vera's instructions, much like Eliza's instructions, are fund things other people don't think is particularly palatable. Fund stuff government won't touch. Fund big picture thinking in science, and let's see what happens. And subsequently, Vera's funding has actually also been utilised another 40 years later to support some of the earliest work around the HPV vaccine as well, again when others weren't touching it. Final chance for the chocky, ladies and gentlemen.
Miles Franklin?
Yes, very good. Miles Franklin.
Who said it?
I did.
All right, catch.
So Vera was a Perpetual client, and we're really proud to still look after her charitable trust structures, and she forms very much a cultural part of what Perpetual is as an institution in terms of talking about philanthropy with our clients, as is Miles Franklin. And I love the Miles Franklin story because Miles Franklin, obviously, aside from being a fantastic writer herself, an author, a passionate Australian and passionate about Australian literature, she decided during her lifetime she didn't feel as though she had the capacity to give, but she actually set aside money during her lifetime that she was going to have her estate utilise to set up a charitable trust structure that ultimately would provide an award every year for an author who best wrote about Australian life in all of its faces. And ultimately that's what she did with $17,500. So in 1954 she put $17,500 from her estate into a trust structure, and today we have one of Australia's most prestigious literary prizes. It's distributed more than $1 million in income over that period, and it's grown in size to over $1 million, and it will exist forever supporting Australian literature and growing Australian literature and building up our cultural sense of self. And that's the power of her philanthropy. It didn't need to be huge. It just needed to, have a focus in terms of the intent of what she was attempting to achieve. So I love that story as well.
And she was also a suffragette.
She was absolutely, very, very significant feminist in this country too. And I love this connection also. This grumpy fella up in the right-hand corner, apparently he was a lot of fun at parties, if we're going to stay on the party theme, is Patrick White. The very first Miles Franklin Literary Prize went to Patrick White for his novel Voss. And Patrick is also Australia's first and only Nobel Prize winner in literature. And many of you might know the story. Patrick was asked, you've won the Nobel Prize, what are you going to do with the prize money? And he said, I'm going to buy a stereo, which apparently he did. But there was about $80,000 left over from the actual financial prize that went with the Nobel Prize. And Patrick was also a Perpetual client. And the story goes in at Perpetual that he came in and he said, I'm going to give 10 $8,000 awards to Australian authors who haven't been recognised the way I've been recognised during my career. And for whatever reason, he decided instead, perhaps hearing the stories of people like Miles Franklin and Vera Ramachotty, to set up a charitable trust structure. He put the $80,000 into a charitable trust and decided each year he was going to get together with his friends and they were going to decide on one award, much like the Miles Franklin, to recognise an Australian author. So that $80,000 was put into trust in 1974 and today has distributed more than $851,000. Now, if Patrick had decided to give over those awards in 1974, what a generous and fantastic gift it would have been. But now again, he's provided, instead of 10 awards, 43 awards and distributed nearly $1 million from that capital injection. And the capital itself has grown to nearly $800,000 in size. So the great part of that story is, again, this isn't a Warren Buffett type philanthropic story. This is, genuinely about somebody that had a windfall moment and decided to use that windfall to establish a legacy around something that he was passionate about. And the great part about that is that it will exist for the benefit of Australian riders forever. It will always be there, it will always exist. So that's a really exciting part of it as well. So we know that bequests ultimately are growing, but a lot of people say to me, why do people utilise structures as opposed to giving directly? And I would say consider giving directly if you've got one organisation that you're passionate about, and sit down with them and have a conversation around ultimately why you want to provide a legacy to them and how you're going to go about it. But if you've got multiple organisations, or you're not necessarily sure on which organisation you want to gift to, then structures become a really fantastic tool for you to utilise, and we're seeing growth ultimately in those more broadly. But the benefit then for the community sector is when you put something into a structure, a trust structure, these are literally trust structures that can exist in perpetuity. Essentially you're putting the capital in and you generate income off that capital, and the income is distributed out to organisations you care about or to issue areas that you care about forever. And ultimately that means for the community that there is an income source that will exist forever. And in a world where we are seeing contracting government funds going to the social sector and it becoming very competitive to access those funds, any way that we can generate additional resources for our communities, any way we can generate additional resources for research, for education, for relief of poverty, any way that we can do that is of benefit more broadly to the Australian community. So these are the things that I talk to my clients about, and I know that Chantelle does as well. So look, setting up a philanthropic structure via your estate, or doing it while you're living and making it a beneficiary of your estate is often a really terrific way to provide that sustainable gift to the charities that you care about, and that's really important. We also have ultimately individuals that understand the power of legacy. So again, having worked really hard over a lifetime, see it as an opportunity to demonstrate the legacy of that hard work, or the hard work of the individuals that they care about and their families. One last one that we touch on occasionally is those philanthropic trust structures are increasingly used by families to manage concerns around intergenerational wealth transfer. So the old story of grandparents made it, mum and dad sustain it, grandkids below it, that is absolutely true. Only one in 10 families survive the third iteration of the intergenerational wealth transfer. So we did a piece of research and went, okay, well, we really want to know what that 1 in 10 family group looks like. What are the characteristics of those families? Lots of things. Communication is an issue, access to advice is an issue, all of those types of things. The most consistent characteristic across all of those family groups that were examined was philanthropy, an active philanthropic culture within the family group. And that's a way for grandkids to learn about the power of money, the social values of the family group, but it's also a really interesting way for them to learn about money management, trusteeship and governance when you use a philanthropic structure to enable them to come into investment meetings and things like that. So it's a really interesting wealth protection mechanism as well. So all of these things are worth doing while you're living and considering doing while you're living, but absolutely can be easily put into your estate plans as well. I'm going to finish up now, just so we do have a couple of minutes for questions. We know at the moment that 30% of Australians say they intend to leave a gift to charity via their estates, but only 7.5% of Australians do. So it's really important that you either raise it with your estate planning lawyer, that this is something that's really important to you, if it is, because some estate planning lawyers, they're not all as great as Chantelle, they're not all as great as the ones that we have at Perpetual. They won't necessarily raise it for you. So if it is something you're passionate about, don't make it the last thing on your fact find, make it one of the things that you really talk about. And you can see the difference around our client base that we deal with. 65% of the clients that we work with end up leaving a charitable bequest. And we think that's because we make philanthropy part of every conversation with our client group, not just the last tick of a box at the end of it. So that's us. Have we got, Chantelle, do you want to take questions up here? Kerry, is that how you want to manage it?
I'm managing it.